Hi, my name's Isaac Shutt. I'm a wills, estates, and probate attorney headquartered in Richardson, Texas. Today we're going to talk about how to contest a trust or a will. A lot of times our clients come in and they explain that a loved one has died, maybe a mother or a father, and they say that some other family member has taken a will to court and there's no way that will is valid. And so the first thing you should do if you want to contest a will or a trust is to meet with a lawyer. A lot of times a probate lawyer who handles litigated cases will actually give you a free consultation. That is really a good idea to do. If you get 3 minutes of that attorney's time for free, that attorney gets to learn a lot about the case and really help you decide first whether or not you even have a case. Now, whether or not you have a case is really depending on a couple of things. The first thing is, do you have a copy of the document that you want to dispute? So if we look at that document itself, the first thing we're going to look at is it just missing something? In other words, under Texas law, a typed will has to have the deceased person's signature, but it would also have to have two witnesses and a notary. Or at least two witnesses, and a lot of times also a notary to make it what's called a self-proved will. So a lot of times what we're going to look at as an attorney is, does it just pass the mechanical requirements of a valid will? Does it have the right stuff under the law? Now, after that, we're going to look at a little bit deeper things. Like, for example, when we look at the date that the will was signed, that date may give you some concern because even though it contains a signature, has witnesses and everything like that, you may know that as of December 27, 2019, there's no way your mom had mental capacity to do a will. You might have it in mind that, mom had Alzheimer's or dementia, and there's just simply no way on that date that the will was allegedly signed, she could have understood what she was doing. And so that's probably the most common grounds for challenging a will. Besides just, does it not have the right stuff? I think the most common ground is that there was a lack of mental capacity. And so sometimes we have to get some doctor records and then a doctor's opinion about whether or not, yes, in fact, on that date she had the ability to make a will or she didn't have the ability under Texas law to form the right frame of mind to create a will. Now, there's sort of a twin to mental capacity, which is called undue influence. And undue influence is kind of like mental capacity in that to prove that the person was unduly influenced when the will was signed, you're showing that there was a weakened mind, like maybe they were in the hospital or something like that, and that somebody else exerted pressure on them, forced them to sign a will. And that if there hadn't been that undue influence, the will signer would not have allegedly signed that document. So that's another thing we'll be looking at is the twin to mental capacity, which is undue influence. So there can be some other things too. Those are the most common. And so the one thing I really want to point out to you though is that instead of going to Google and instead of just relying on this video, you should really go talk with a lawyer as soon as you can, because like I said, a lot of them will offer a free consultation. And so there's this old attorney saying, you might have heard it before, called a race to the courthouse. There are important deadlines that you can miss by not doing something. So instead of wondering, instead of thinking maybe I have a case, maybe I don't have a case, just get to an attorney as soon as possible, because that attorney may freak out and say, we need to get your case filed as soon as possible. Your brother has already offered that will for probate. You need to challenge it before there's a hearing. Otherwise, you may have a much more difficult case. So the number one takeaway I want from this video to be is, don't you make up your mind about whether or not you have a good case. If you have an inkling that there's an issue, just go see a lawyer and then let that lawyer help you evaluate that. Now again, my name's Isaac Shutt. I'm a wills, trust, and probate attorney headquartered in Richardson, Texas. And we do offer free consultations, especially in contested cases. We'd love to hear you. We handle a lot of will contests and we'd be happy to hear from you. To learn more, you can go to www.shuttlawfirm.com, and Shutt is spelled S-H-U-T-T.